Um, the same Ministerial Council decision talks about the important role of whistleblowers and the need to provide sufficient protection for whistleblowers. Again, then it also says that participating states should be aware of the important role of an engaged and well-informed civil society and of independent media in fighting corruption. So we think that the type of arguments that the OSCE anti-corruption thinking produces can also be important for our work in furthering the human dimension and in protecting civil society and civil society activists against attacks and harassment, and in finding and in emphasizing the need to for international levels and other participating states to be aware of what happens in particular other participating states. Final thing I want to say, we have here now speakers from Azerbaijan and Ukraine. This is two countries on which a lot has been published, also in international media, about issues of corruption, where corruption has been a major source of both of governmental repression and of citizen dissatisfaction, and has contributed strongly to movements that have led to the overthrow of government. These definitely are not the only countries where there is a major issue of corruption, both to the east of Ukraine and to the west of Ukraine. You have phenomena that are of concern. Take major demonstrations in Romania over the issue of corruption during past summer. Take very concerning news from Moldova about the involvement of leading politicians in major corruption scandals. Take news which I heard a couple of months ago from Bulgaria about people who address corruption and bad governance at the local level, about them being harassed at the local level. Take news about the killing of journalists in Malta and Slovakia, probably or very likely related to them reporting about corruption issues. So there is not in all these countries a pattern of systematic government repression of anti-corruption activists, but in too many of the countries where you don't have systematic corruption, you have a pattern of at least parts of the government, law enforcement and judicial institutions overlooking or maybe not exercising their full powers and using their full efforts in fighting corruption. And this is something that we need also to address and to recognize. I move to our first country speaker, Emin Husseinov from Azerbaijan. Please go ahead.
Thank you, Harry. Thank you, Harry, and thanks for organizing side event is these very important topics. As many of you know, we have too much political prisoners for 10 million population. It's not new problem. It's problem which is continued in Azerbaijan last 18 years. Since we are member in Council of Europe, and as member of Council of Europe, we have obligation to zero tolerance against political pressure. And the story with corruption started developed since Azerbaijan have membership in these organizations. When Azerbaijan, as like our government says, new state, try to participate in very important international institution, which is main of his role protecting human rights in Council of Europe area. They try to involve European politicians to some serious and dirty political manipulations. And stories start developed in 2013 when German politicians Christoph Strasser appointed as from Parliamentary Assembly of Council of Europe to position from political prisoners, special rapporteurs for political prisoners in Azerbaijan. This person not allowed to come to Azerbaijan, even his mandate gives this possibilities to him, but Azerbaijani government don't give visa. But later, this man, brave man, prepared a very strong report when put all of these victims' names, but this report not approved in Council of Europe, and many his colleagues voting against this report. And after this started new stories when human rights community, not only single organization, but many of us, Harris organizations, many organizations in Azerbaijan, our organization, start to fight with these negative issues. When human rights community prepare political prisoner list, special rapporteur also approved this list, but some dirty politician for some monies voting against the human rights, against the principle which is their promises to his own people in his own nations to protect these principles and values. They're voting against to these principles. They lie to his voters in his own countries, and they not protected human rights in Azerbaijan, because human rights issues is not only issues from one country. If any country saw serious problem in certain state, they must be intervened. Again, the story with the political prisoner report shows for Azerbaijani government spent millions of dollars to buy political influence. From 2012 until 2014, only by Estonian branch of Danske Bank, they are organized unbelievable money laundering scheme, which is total amount from these 2 years of this dirty 16,000 operation is $3 billion. $3 billion. I don't know how much exactly they spent for buying political influence in the Europe, but it's many cases, which is last 3 years published in the European media when German politicians, Spanish politicians, Italian politicians received money and votes against his own principal European values. And now we already have quite successful international teams, which is OSCE and ICFJ, which has published these stories. Azerbaijani Landromat, Russia, Moldova for money laundering. And this shows that it's not problem of Azerbaijan or Azerbaijani people or Azerbaijani political prisoners. These guys, high-level politicians, which has falsified elections, sometimes in his own state, start to export his dictatorship values to Europe. And when we speak about about single Europe, strong Europe, which is respect democracy and human rights, you need to start to think about this, why this happened. Why Azerbaijani politicians using not only Azerbaijani banking system for money laundering, they are using American system SWIFT for money laundering. This is crime which has happened on the US. They are using European financial systems. They are using European banks. Only Danske Bank says, for we are participate in these stories and we have received 150 million total debts for 2 years from laundering 3 billion euros. And this bank recently says, they are apologized in front of the Danish population, but I think this bank also must be apologize in front of not only Danish people, also in front of the people of Azerbaijan, in front of the people of whole Europe. And this bank announced for the money which is they are accumulated on his profit balance, they spent all of this amount for fighting against corruption, to supporting NGOs around the world. They already announced this months ago, and let's see what's happened. But again, we still need to continue our fight. It's only part of the iceberg. Which makes Transparency International and other colleagues organized similar side event in the Parliamentary Assembly of OSCE recently in Berlin, when they call the OSCE Parliamentary Assembly establish independent institution inside the OSCE Parliamentary Assembly, which is able to prevent all of this corruption litigations for the future. And right now, concluding for my speech, I try to call to OSCE Minister Council, to Committee of Ministers of Council of Europe, and all international intergovernmental organizations. For each organization need to be established internal and external institutions which is controlled them to prevent this corruption, because price which is we are paid, it's very huge. We lost our families, we lost our countries, start many tragical wars around the world, and all of these reasons, this is corruption, because politicians from Kazakhstan, from Ukraine, from other states, even able to buy people in US, and now I think my colleague able to explain this story with Manafort. But again, we have to let all peoples want to live in transparency community, and without transparency, we never have success to give guarantees to our people with values of human rights and rule of law, because corruption is biggest enemy of these main fundamental values for all of us. Thank you very much for your attention, and thanks again for Netherlands Helsinki Committee organize this important side event.
Thank you, Amin. There will be opportunity for questions or comments, I propose, at the end of all our introductions. So I move to Mikhail Kamenev from Ukraine. Please go ahead.
Thank you, Harry. I'm talking about the situation in Ukraine, where in last years the anti-corruption reform and all anti-corruption initiatives are very popular, and everyone tried to be the anti-corruption politician or anti-corruption journalist or anti-corruption activists. But when anti-corruption journalists and activists are, they tell the truth, and on the other hand, the government, they should be the anti-corruption politicians only as a result of the not as a result of their political will, but as a result of the pressure by activists and even our foreign partners and international organizations. It's very good, because the history of anti-corruption is the history about about the truth, about the dignity, and about human rights, because corruption is about the unlawful using of government money and government powers. So, we have a lot in anti-corruption field. For example, the establishing of National Anti-Corruption Bureau is the new investigative body in Ukraine, which investigates in high-level political corruption, and also the establishing of the Anti-Corruption Prosecutor's Office. They have a lot of problems in their work, and they sometimes violating the rules, violating the criminal procedure code, violating constitution. But that's the new generation of people. I think that that's problems will solve by constitutional court, by new politicians. publications by all of our activists, lawyers and researchers. We have the establishment of e-declaration, electronic declaration of all governmental officers. It's, I think, nearly 1 million people who should put their declaration into electronic system every year. And after that, we have the emotional response of the members of parliament who who adopted the law which imposed the obligation of all anti-corruption activists to also put their declaration into into this register. But it looks like the emotional response. Government know what every people have. They have registers of property, they have tax information and so on. They only want to show for ordinary people that they think that anti-corruption activists have very, very high level salaries and a lot of property, but actually it's not true. And the real reason that we want to charge these people for the crime they not do this now, but in future I think that will be the problem. That's the huge response of the Ukrainian political system. On the other hand, we have the separate attacks on the activists. For example, for the last days, we have the problem when the head of the National Anti-Corruption Bureau, Artem Sitnik, he provide, as General Prosecutor's Office think, that he provide some secret information from the investigation to anti-corruption journalists, some of them, and they make this information, they make the publicity for this information, and they have no proof, and they after that, they ask the court to permit the access to the information of all telephone interrogation, all SMS of Natalia Sedleska. That's the editor of one of the famous Ukrainian anti-corruption TV program called Scheme. And they received the court approval for taking the access, not for only the time when the meeting of Mr. Sitnik and the journalist have the place, as they think, but for 17 months. 17 months, it's a lot of time, a lot period, and we understand that there's no reason to receive a lot of information about the professional work of the journalist. And after that, the Prosecutor General said that they will put only in the information of the several dates, but they can do anything using this court of improvement, and we will not have information about that because that's it's the secret information. Also, we have the attack on Katerina Handzuk. That's the head, one of the officials of city council from the south of Ukraine, the big oblast center. One man attacked her and put the exit into her face, and she had big injuries, and the civil society start a very wide campaign of pressure on the police and on the prosecution office. They have only one question: who is the customer of the attack on Katerina Handzuk? Because the police, they have several people who they think attacked her, but they don't know, or they said us that they don't know who is the customer of this attack. That's one of the problems. And another example One of the good reform is the trying to take the civil society activists to the court reform. We have established, the Ukraine established Public Integrity Council. That's the independent body in the judicial system, which consists only from civil society activists. And they, this body helps the Higher Qualification Commission of Judges to make the recruitment of the new judges, even the judges of the new Supreme Court of Ukraine. One of the members of this Public Integrity Council, that's attorney Roman Maselko. He's one of the attorneys of the families after the Revolution of Dignity, the families which are in criminal cases against the riot police and so on. Roman Maselko, he criticized the judicial reform. He criticized the process of recruitment of new judges. He criticized the some cases of National Anti-Corruption Bureau, and after that, in this year, he was accused for breaking the attorney's ethics code, and now he some gongos said that he breaking the ethics code second time, and they claimed to the independent attorney's body to suspend his attorney's license. And we think that it can be, and it will happen, and it's a big problem because Roman Maselko is, I think, one of the famous Ukrainian attorneys from the civil society. So that's the some examples of the problems, but sometimes people think that we can solve this problem only using pressure and make these cases to the provide these cases to the public, to the international bodies. But the real problem is that our criminal system is not reformed. We changed the name of militia to police, and that's the same people. We never changed the criminal police. Then we tried to change the prosecutor system, but it's never changed. We should focus on the reform on the criminal procedure. We should focus on the system which is interesting for not only anti-corruption activists, journalists, and civil society activists. It's the important system for all people, because everyone can have problems with this system in future. So for international community, it's important not to only pay millions of dollars for the reforms without control. It's important to invite civil society activists, research experts, think tanks to the process of reforms, to process of choosing the way of giving money and the reasons of this giving. And it is important to invite civil society in this process. I think that if we make the real reform of Ukrainian criminal justice system, we will have no problem with attacks on activists. Thank you.
Good, thank you very much, Mikhailo. Now I move to Melissa Hooper, our final speaker, who will talk about a number of new international initiatives and mechanisms that may help, will help in fighting corruption and in addressing people who are involved in corruption. Please go ahead.
Thanks, Harry, and thanks to me and Mikhailo for highlighting the situations in Azerbaijan and Ukraine. but I also wanted to mention in response to Amin mentioning that we're noticing more networks of corruption that cross borders and that involve numerous countries, including money coming into the US or the UK. That one trend that I see now is the development of what we call beneficial ownership legislation, or legislation that seeks to have shell companies actually register a person or a list of persons that are behind the company. And so we have had the Sanctions and Money Laundering Act passed this year in the UK that requires such a registry, and that we are seeing momentum for that kind of legislation in the US, so we could see that pass within, I would say, next year. So I see those as helping us come at these networks, cross-border networks. Excuse me. But I think one of the more innovative or new strategies that we're seeing develop is the use of global Magnitsky legislation. The first Magnitsky Act was actually passed in the United States in 2012, and that focused entirely on Russia. It took its name from Sergei Magnitsky, who was a whistleblower in Russia, and who died in prison there as a result of mistreatment because he reported grand corruption in Russia. So that was passed in 2012. This legislation expands on that. It is global, so it seeks to sanction individuals that have committed acts of corruption. It also addresses individuals that have committed gross violations of human rights. Unlike the Russian legislation, however, which was mandatory if a certain standard was met, the standard in the Global Magnitsky Act is elective. So we need advocacy around this act. So the act was passed in 2016 in December. So it has been around less than 2 years. It's pretty young, and specifically the act says that the President of the United States, the executive, can block or revoke U.S. visas and can block U.S.-based property and interest in property, so that includes financial accounts in the United States, if an individual has been found to engage in gross violations of human rights, and there are some examples of that, or acts of significant corruption. Now, what's interesting about that is that the standard is that it has now modified a little bit. We saw in December 2017, our president signed an executive order related to global Magnitsky, and it actually broadened the standard. It made it a bit easier to sanction individuals, and so some consider that a human rights win for the Trump administration. It essentially said that instead of gross violations of human rights, the standard is now serious human rights abuses. And so we consider that to include gross violations, but it could include some other somewhat lesser violations as well, depending on the situation. It also said that acts of corruption don't have to be acts of significant corruption. It simply said acts of corruption. So this makes it quite broad. Finally, I should note that in the original Global Magnitsky Act, there was a focus on who the victim was, that there had to be an act perpetrated against a whistleblower or a human rights defender, whereas in the executive order, there's a focus on who is the perpetrator. And so this means that there does not necessarily need to be someone who's attacking a whistleblower or human rights defender, as long as there is a corrupt government official who is responsible for or complicit in these abuses or corruption. So in terms of what constitutes corruption under the Act, it's intentionally broad, but some examples are misappropriation of state assets or expropriation of those assets for personal gain. It's corruption related to government contracts or extraction of natural resources. bribery, of course, and then transfer or facilitation of transfer of proceeds from corruption. So again, it's quite broad and it can reach extenuating circumstances. It's also important to note that when we are preparing designations or recommendations for designations, that the U.S. is looking for acts that have occurred within about the last 5 years, because the intent is that the sanctions be used to produce change, that there be the potential of a reaction and a response from the private individual that is being sanctioned. The standard for sanctioning is a reason to believe that there has been a violation. So again, the U.S. government is acting on a pretty, I would say, weak or low standard. So another significant part of the Act, and part of why I am here, is that it specifically contemplates that NGOs will be involved in making recommendations to the U.S. government about individuals that should be sanctioned. The Act states that the President shall consider credible recommendations of NGOs relating to both corruption and human rights abuses. As a result of that, our organization, Human Rights First, has partnered with about 75 other organizations to develop a coalition, and through that coalition we identify countries where we think there should be a case developed, a designation case developed, and for the last 2 years where we've had the Act, we have submitted each year a list of individuals with research and evidence showing why we think the U.S. should designate those individuals. We have submitted 15 individuals in the first round, 20 in the second round. In each round, we had about 1/4 of those related to corruption. We have seen some of those result in designations from the U.S. government, both related to corruption and human rights abuses. A couple of people, these are actually, I will say these are not people that we have recommended, but just some examples of those that have been sanctioned under the Global Magnitsky Act by the U.S. government include Gulnara Karimova for her corrupt schemes related to telecommunications, and Slobodan Tesic for corrupt schemes related to weapons sales. He's from Serbia, Karimova was from Uzbekistan. We've also seen corruption cases from Honduras, the Gambia, and Congo. Let's see. So I think if organizations would be interested to work with us on corruption cases in the U.S., we're looking forward toward developing cases for designations under Global Magnitsky that examine this network effect, and so they look at cross-border and multi-country corruption, and so we'd be interested to work with organizations interested in that. So in addition to the U.S. Global Magnitsky Act, there are other countries that have passed similar legislation. Canada passed similar legislation just this year, but it hasn't been used yet. But it is very similar and actually based on the U.S. legislation. And then also in the UK, the piece of legislation I mentioned earlier, the Sanctions and Money Laundering Act passed this year, is aimed to be a Global Magnitsky type. It has a Global Magnitsky type section in it. However, as some of us learned this morning, that is considered a post-Brexit piece of legislation. So it will only go into effect when Brexit goes into effect. Because for now, the UK considers its sanctions to be pursued through the EU. And so currently that will not be used, but we could see that used in the future. In addition to that legislation in the UK, there's the Criminal and Finances of Proceedings of Crime Act that does allow for some sanctions if there is, for example, a torture of a whistleblower. And so in that way, that this is a court proceeding where a prosecutor can approach the High Court and can ask for sanctions, seizure, again, of assets that relate to corruption that has been engaged in by an individual who participated in the torture of a whistleblower. It is much more specific than what we have in Global Magnitsky, which is quite broad. In addition to the UK, Canada, and the US, the Baltics have Magnitsky-type legislation that, as I understand, focuses pretty much entirely on visa limitations or denial of visas. It does not involve seizure of financial assets. And then finally, I know that Moldova is currently considering similar global Magnitsky legislation. I can stop there.
Thank you, Melissa. You have a question? Please speak in the microphone.
Just to mention about the draft law was registered already. So let's see if it will be adopted as in Moldova we have parliament elections in January, and we have doubts that it will be adopted in this month.
Good. Any further contributions from the floor, considerations, questions, reactions? Please. Yes, please.
Thank you. My name is Pieter van Loekersloe. I am a member of the Foundation for Netherlands. Thank you, first of all, for organizing this subject. Very interesting, and I'm happy to hear and thank you very much. Thanks to the three speakers for their introductions. I actually would like to take on the role of devil's advocate for a moment and ask Ms. Hooper if she sees, say, at least some tension between Magnitsky legislation and the right to a fair trial or due process, because basically you're punishing people for without giving them the chance to defend themselves or without the intervention of an independent judge. So I'd like to hear your views on that side of the equation. Thank you.
Okay. Yes, I do see that tension. Let's see. So I'm going to give you a bit of a long-winded response, but with some examples of how we see that tension playing out. First of all, when this coalition put forth our first list of recommendations, we did so publicly, and we announced that we are going to be making these recommendations. And in response to us doing that publicly, we had an individual threaten to sue us for using the word oligarch. And so we, as a human rights organization, then had to expend resources in hiring an attorney and considering whether we had made any mistakes in using that word. And we negotiated with that individual, and nothing came of this threat, but it was definitely a threat. And I think from that, we learned that we already, as an organization that is made up of lawyers, we were the Lawyers Committee for Human Rights, we think of this as a legal proceeding. And so while the US government maybe has relaxed the standard, we see it as a standard that we need to meet by providing evidence of every element. And we also urge the US government to ensure that when they are sanctioning individuals, that they are doing so based on evidence that meets the legal standard for a crime of torture, cruel, inhuman, or degrading treatment. That is what we are providing to them in our materials. However, now we also don't publicize our recommendations because we were also, in addition to the struggle that we had with expending a lot of resources to defend what ended up being a frivolous suggestion of a lawsuit, we also were told by the US government that if we publicize this information, then this allows individuals that might be sanctioned to move their assets, and it blunts the force of the sanctions. And so I think our response now is that those that are placed on the list, we are urging the U.S. government to ensure that it is using a principled standard, and that that they are not using this politically. And when we believe that they might be doing that, we have been speaking out publicly, and I can give examples of that. But in terms of when an individual placed on the list can challenge it, that happens currently when they are notified that their assets are going to be seized, and then they can challenge it in a court of law in the United States.
Good, thank you. Yes, please go ahead.
About the global Magnitsky Act. First of all, the United States is easier to adopt such laws. Big country, big power. However, can you imagine Moldova would refuse or make some adopt such laws against Russia? The European Court of Human Rights has issued against Moldova more than 380 judgments, of which about 50 concerns the human rights in the Transnistrian region of the Republic of Moldova, where the Russian army stays now. I doubt that Moldova can adopt such laws because similar actions might be adopted by the Russian Federation. Secondly, I have doubts that if that such a law will interfere with regard to the whistleblowers or the money laundering issues that were mentioned before. It is a fact that through the Moldovan banking system that was supported by the Moldovan judiciary, we have laundered about more than $22 billion. Still, we don't know. This is a piece of the how much amount of money. Thus, probably some Baltic states adopted some small steps in this regard. However, it's important for us to understand what the U.S. can do for us, small and not so important countries in the international arena. However, sometimes the U.S. embassy or the U.S. government can consider not to send for conferences or some international events of prosecutors, policemen, and other persons that are already subjects of the European Court of Human Rights judgments or even the Moldovan judgments in this regard. Thank you.
Yeah, I don't. Your final remark about prosecutors and other people in the law enforcement and criminal justice system in Moldova, I don't understand.
I think there.
Sometimes global Magnitsky or similar, for example, for Moldova, might not be adopted as a document by the Congress of the United States, but at least can be considered by the U.S. Department while supporting some institutions, not only from Moldova, but also from the other states.
And I think that you were referencing that if the U.S. has concerns about certain judges or prosecutors or actors, that perhaps it shouldn't be training them or inviting them for participation. There is another law called the Leahy Law in the United States that is supposed to address individuals that have committed serious human rights violations, who are police and prosecutors, and essentially the U.S. should not be working with them if it has those concerns. There isn't one related to corruption, and I guess what you're pointing out is that maybe there should be, which is a good point.
Yes, good. Thank you. Any further points or questions or remarks? Yes?
Honestly, knowing nothing about the applicable legislation, this is very confusing about Magnitsky Act. Is it related in any way to the delay vetting process, for example? Which I think maybe relates to vetting process, which I understand is the AA vetting process, and I wonder if you could remark on that, how it relates, if it relates.
Sure, so that's what I was just referring to, the Leahy law, it's the vetting process that occurs under that law. That is solely human rights related, and it relates mostly to torture and cruel and degrading treatment. If there is evidence that certain law enforcement officers have engaged in that treatment, then the U.S. is not supposed to cooperate with them. I'll be honest that I don't see that process as always being effective because police officers don't always give their full information to the U.S. and so that process sometimes is ineffective, or the U.S. honestly isn't, doesn't do its due diligence in completely researching the individuals that it works with. So there are gaps for sure.
Be strengthened. I think if you have thoughts on it. How do you think it could be strengthened? If it would be possible to strengthen it, how would you propose doing it?
The Leahy law, or the Leahy vetting process. I think it would be great if there could be more civil society participation or reaching out to civil society that are monitoring police and prosecutors who might be able to identify concerning actors, maybe ahead of time, and even flag just, for the U.S. mission, think about, these are the people that we have gathered evidence on. We're not saying you have to ban them, but we would like you to do your due diligence around these people if you think that if you are thinking to cooperate with them, something like that.
Yeah, good. In the past existence, I worked in another human rights organization, and I did a lot of work on Colombia, and I know that Colombian NGOs were submitting a lot of information on units of the police, units of the military that they knew were involved in human rights abuses to the U.S. Embassy, and then for inclusion in the vetting process. So I think there is, it doesn't just need to be at the request of the U.S. authorities to submit this type of information. It can also be done, by civil society itself. But again, this does not touch the subject of corruption. Might be interesting indeed to see whether this could be extended, or whether the Global Magnitsky Act, things can be, surely someone who would be on the Global Magnitsky list would not qualify for this type of training. But the training vetting threshold is lower, I guess, than the Global Magnitsky threshold. Any further or more ideas, contributions? Nothing at the moment, then yeah, Melissa, please.
Since we have talked quite a bit about Global Magnitsky, and there were concerns expressed earlier about what is Global Magnitsky and what are we using it for, I just wanted to say that as the human rights community, we do want to urge that all of us not only look at this option, but at other human rights options, at using regular old human rights mechanisms to hold individuals accountable and to push governments to hold individuals accountable. That's very important. Global Magnitsky should not be the end-all be-all. This should not be our solution. It is one possible strategy to be used. I think that in the United States right now, we believe that there may be an overemphasis on sanctions by our own government. So we are willing to use this tool, but we want to use a full list of tools, this being just one.
Thank you very much. I think we may ask Emin Mihailo whether they have anything further to say at this moment.
I just try to use the chance to call to OSCE member states again. Don't forget victims, which is lose his life for fighting against corruption. Many of them it's investigative journalists like Daphne Caruana Galizia, which is recently killed in October 2017 in Malta, and other journalists or investigators which is try to publish and make strong investigations. We all needs to remember them, and this list, which is right now we speak about global Magnitsky Act, all of these victims must be included to these legislative initiatives to start potential investigations against criminal groups in the governments, which is many of them quite most corrupted government in OSCE area. And I think it's very serious challenge for OSCE because at least half of the member states of these international bodies have very, very strong problems with the corruption issues. Most of these countries is members from post-Soviet countries, which is since from our independence, we don't lose the problems with corruptions. If you ask me which, for example, Azerbaijani courts most corrupted in the Soviet area or right now, I told you, corruptions today is much more, it's uncomparable higher compared with Soviet era. That is, but still we named like independent state. And this is, again, it's obligation and commitments of OSCE established already, it's not too late, mechanism which is successfully able to fight against corruption. It's our role as NGOs, we are organizing side events in Parliamentary Assembly, OSCE meetings here in Ministerial Parallel Conference, but our feedback is not enough. Without strong cooperation with governments, we're never able to have success to solve this strong problem, which is like cancer from whole our planet. Thank you.
Thank you, Emin. Mikhailo, do you have final word?
Yeah, thank you for the invitation, and at the end I want to say that it's very important to fight in corruption, but not to forget the principles of European Convention of Human Rights, OSCE commitments, due process clause, and so on, because the most important thing is the dignity, human rights, guarantees, and many other things. And also we should protect the people who promote the fighting against corruption, the people who make the articles about corruption, activists, and many other things, because it's about the future of our countries. Thank you.
Thank you. Thank you. I thank you again all for coming, and we hope to pursue the subject of the linkage between human rights and corruption and the fighting of people who abuse their power, both to gain themselves and to suppress others in all relevant venues of the OSCE and of other international organizations. So I hope you will hear again from us. Thank you.